Monitoring Committee of the Honorable Supreme Court today, 2nd January 2007. It has been desired by the Honorable Member of the Monitoring Committee that no marriage parties, etc. should be organized in the lawns outside the restaurant. Further, ASI had issued a notice on 25th November 2003 for carrying out unauthorized construction by you. You are requested to come forward with a copy of the notice dated 25/11/2003, reply thereto and the decision of the ASI. These papers to the Monitoring Committee and therefore you are requested to take immediate action. So I immediately put them on notice on 7. Paragraph, they said there is no breach of violence. Second paragraph, we would not organize any marriage party in the lawns outside the restaurant.
But you had given to them for a banqueting facility in the lawns, right?
Yeah.
The banqueting facility in the lawns also could be...
We didn't say lawn. We didn't say lawn. We did not say lawn. We never said lawn. The problem is, who do I claim against? It's the Supreme Court.
Time. Just put your house in order. Sir, just Nariman had issued notice in January 18th, coming after 6 years, Section 11 petition. And the office report indicates service is complete. Keep it next Friday.
At the outset, Lord, I must point out that the applicant company is now under liquidation, Lord. That's what we've learned, Lord, that the applicant company is now under liquidation. I, in fact, inquired from my learned friend on the other side. He was good enough to send me the order. May I request for your Lordship to have it after 2 weeks? We'll intimate the liquidator.
The liquidator will have to come on the record. How much is the claim?
No delay, my Lord. There's no delay.
How much is the claim?
Claim would otherwise be in millions, Lord.
It arises out of a share subscription agreement.
Lordship, my Lord.
Lordship, in fact, to that extent, sorry, I appear for the respondent. In fact, to that extent, what we've been told, my instructions are that there was a litigation that ensued between me and the guarantor. And the guarantor has recovered the, we've been able to recover the money from the guarantor in execution proceedings. There's also a settlement agreement which has been executed, and therefore we have given up the shares. So technically, there is nothing surviving in this matter where the borrower seeks to now initiate action against me when there is that settlement where the guarantor is a...
You first recovered from the guarantor.
Yes.
And then the settlement was with?
So the recovery was pursuant to a settlement only in execution proceedings.
From the guarantor?
From the guarantor. And I was holding shares which I have now given up pursuant to the settlement agreement.
I see. The shares which you held.
I was the investors who held shares. Because I got the money, I had given up on those shares.
So really speaking, you have no claim left now. And what is your claim against them?
But for the breach of the agreement, my Lord, whereby they sought to invoke the put option, my Lord.
Anyway, you take steps within 2 weeks other than...
No, my Lord, but subject to the claims of the applicant.
What you get now, you are into liquidation.
By the applicant.
Who will pursue the claim?
Precisely, my Lord. That's the...
The Lordship also, the order of liquidation is of 2019 that I have. So, I'm not sure if any steps had to be taken by the liquidator. Probably 5 years, he would have taken some steps.
This was filed when? This was filed in 18. The liquidator has not taken steps to pursue the claim.
But I am handicapped to that extent, Lord, because I don't know whether the liquidator...
An order of liquidation which we don't have. Learned Counsel appearing on behalf of the petitioner states that the petitioner is in liquidation. So stop. The order of liquidation passed on.
I understand, my Lord, on
1st October 2019.
1 October 2019. Full stop. No steps have been taken by the liquidator until date for being brought in the record. Full stop. We therefore dispose of the petition at this stage. However, permitting the liquidator, if he is so advised, to move appropriate proceedings for restoration and for restoration and for being brought in the record in the proceedings.
I'm obliged, Your Honor.
Dispose of. Yes.
May I please?
May it please, my lords. My lords, I appear on behalf of the petitioner. I'm seeking discharge in this, my lords.
Your Lordship, I am appearing for the respondent. As per my instructions, the matter has been settled with the petitioner on 16th January 2023, and the petitioner has also given an affidavit cum undertaking to withdraw the present petition.
Where is that?
My lords, I do not have any
Your Lordship may kindly grant me 1 week time to bring it on.
I'd like to bring it on the record.
My lords, my discharge may be recorded. I am seeking discharge.
That we'll first find out whether it has been settled. We don't want to keep these matters pending here. Then counsel appearing on behalf of the respondent states that there's been a settlement between the parties, and as a matter of fact, the petitioner has agreed to withdraw the present proceedings on the request of the learned counsel. List on so that the subsequent developments can be placed on the record on affidavit. Next week,
Please, Your Honor.
we'll take it up next Friday.
Right. Deeply obliged.
You're for the?
I'm for the respondent. None of the respondents has any agreement with the petitioner of any kind.
Where is the arbitration agreement?
Lordships will see. Lordships, I don't know whether these written submissions which are already on the record of Lordships received out.
No. Where is your agreement? The petitioner's is
Annexure P1. Annexure P1.
I think 37, right?
Correct. Lordships got Annexure P1. Do Lordships have the written submission? Because pursuant to Lordships orders, earlier this was listed before a non-miscellaneous day, my lords. Then it has suddenly come up today, my lords.
Annexure A1, is it?
Yes, my lords. P1.
A1. That is like final judgment of the Circuit Court of Florida.
Yes, my lords. Yes, my lords. That is the arbitration agreement.
Where is the arbitration
The
agreement?
arbitration agreement they are claiming, my lords, is at Annexure A8 of the petition, my lords. A8 of the petition. It's not with the petitioner.
Where is the arbitration agreement?
Please, Lordship. I am reading, my lordship. The Lordship had my written submissions on record.
You sure
All
the
right.
document where the arbitration
The
agreement is?
arbitration clause is there in both agreements. Number one, the license agreement.
Where is it? Where is
Just
it?
give it through. Because it's PDF 215, my lords, is in my lord's paperbook. PDF 215, Annexure A8.
You got A8.
It's exclusive perpetual license agreement, my lords. PDF form. This is
The
Lordship
Lordship Cryobanks International Incorporated.
Yes. Neither of these, my lords, is the petitioner. Can my learned colleague permit me? Can I say, my lords?
You show us.
Yes.
You know, I mean, we're also getting impatient because you want
my
to
lord.
show us the document.
Yes, my lords.
Yes.
Yes.
Where is the document?
The document, my lord, says because I have been briefed, my lord, so I have the written submissions of that at A.
No.
All right.
No, we go to the written submission. We have to see the evidentiary material.
At page 166, my lord will have
Annexure.
Annexure A8.
Right, we are on Annexure A8. So that is between Cryobanks International Incorporated
Correct, my lords.
and Cryobanks India
International Private Limited. my lord.
Now,
Yes.
he is a party by the name of
The
Cryoviva Biotech Limited.
Correct. Which is, my lords, the new name of, my lords, the second party to this agreement, Cryobanks India International Private Limited.
So you are the.
I'm a party to this agreement. The first party, my lords, is still in existence. And he is not the first party. And he is claiming to be a party to this without being a signatory.
How are you? How
Yes,
is
my
your
lord.
party?
Now, correct. Yes. If Lord will permit me, please see, my lord says the certificate of the issued by the Circuit Court of the Court of Florida, my lord says. I am a purchaser. Yes, I am a purchaser of the assets of the company Cryobank International, my lord says. And where is all these rights? The business and the assets. When I use the word business, because equity shareholding of that company, Cryobank International and others, my lords. Therefore, if lordship sees the document itself, my case would be I am a successor in interest and the assignee, both, my lords.
So show us the document by virtue of
That
the
document.
instrument by which you step into the shoes of.
PDF.
Yes.
Yes. If lordship sees the certificate.